joining us and giving us those details. Now we are shifting focus. The Delhi High Court in a hearing on the FDTL petition challenging DGCA's relaxations and advisories on pilot rest norms following the flight disruptions expressed dissatisfaction with the regulator's explanation and contradictory communications. The bench questioned inconsistencies in DGCA's letters, the deletion of the clause prohibiting substitution of leave for mandatory weekly rest, and the real-world impact on pilot fatigue, protections and flight safety. Now, while DGCA maintained that weekly rest remains intact and leave is a separate contractual issue, the court here directed DGCA as well as the Union of India to file a detailed affidavit within 2 weeks, clarifying their decisions and the effects of the advisories initially limited until February 10th, with petitioners now allowed to file a rejoinder thereafter. That's the latest. DGCA questioned over the passenger safety norms by the Delhi High Court. In fact, the High Court expressing dissatisfaction over the way DGCA has reacted so far to the relaxation of FDTL norms and not given priority to the safety and rest for crew members. Now, my colleague Sarthak, who's tracking this story very closely, joins me with more details on this. Sarthak, the Delhi High Court, who's hearing the petition on the DGCA relaxation of FDTL norms, has expressed dissatisfaction with the way regulators has been explaining its stance.
Yes, one thing, a pertinent aspect of the case has been put forth in the Delhi High Court, where the petitioner has expressed its concern about the mandatory weekly rest, whether it can be diluted or mixed with leave, and the High Court as well has observed that that there is a lot of confusion in the language. There have been apparently there have been several letters have been issued by DGCA, and there is inconsistency in the language of those letters. Initially, a relaxation limit was given till 10th February, but later on there were some withdrawals that appeared open-ended as per the language of those letters, and the petitioner specifically has argued that a leave shall not be substituted for weekly rest. DGCA claims that the weekly rest has not been withdrawn, and it is a contractual matter. It is a contractual obligation. It's with the FDTL regulations. All in all, the judges were not really satisfied with the vagueness of the explanation given by DGCA, and henceforth they have asked to file a detailed affidavit on the next date of hearing regarding this matter.
All right. So while we understand those are the crucial observations made by the Delhi High Court in this case, what has been DGCA's defense in this matter?
Well, DGCA just simply pushes one point forward, and that is that leave is a contractual matter outside FDTL regulations, and the advisories were only meant to stop the misuse and not dilute the safety norms. What they're trying to say that the weekly offs can be different from the roster that is prepared for the pilots to in a week. And this has certainly created a confusion regarding what are weekly offs and there are sick leaves that are allotted to pilots. How is it different? Are they supposed to be clubbed into one? So there is the High Court has observed that there is confusion in these rules, and that has to be cleared out. And petitioner as well has confirmed that that confusion has to be removed from the language.
Right. Since